Hello, this is Matt on the Moon Family Sedan channel. The class action lawsuit against Ripple might be thrown out. As I reported just the other day, there was a hearing in which the public could participate just in listening mode. They couldn't actually speak in. And a number of you out there listening, no doubt, did participate, although it would be a limited number of you because there was a limit of only 500 slots, and it was required to participate via Zoom. But now that a little bit of time has passed, and there's been some time for lawyers out there to digest what happened, they've been speaking up here, and there have been articles written. I want to share with you some of what has been stated since then. And, you know, the judge in this case, it's the Zakanov versus Ripple lawsuit, the judge stated and here again, just the other day, that the Ninth Circuit Court has not clarified whether courts can certify classes of investors, meaning validate them so you can move forward with the lawsuit, in regards to cryptocurrencies, because it's not clear which cryptocurrencies might be securities. She says it's a new area of law that has not been addressed. It's hilarious, right? Which you know, which is hard to believe for all of you, I'm sure, you know. Since Kim Jong-Ginsler has stated that everything is very clear, right? It's very clear. As a result of this, the lawsuit may end up being thrown out. And I have comments from attorneys John Deaton and Jeremy Hogan on this very topic. But before going further, I do want to be clear that I do not have a legal or financial background of any kind. I'm not offering legal or financial advice, and you definitely should not buy or sell anything because of anything I say or write. I'm just an enthusiast who enjoys making YouTube videos about crypto-related topics, but just as a hobby and just for fun. Now, just to remind you, in case you haven't been caught up to speed on what's going on here, I just want to note that this lawsuit was initiated almost half a decade ago. It was at some point, I believe, in June of 2018, so half a decade. And you got to kind of wonder, and speculation is reasonable here because none of this makes any logical sense upon first glance. But why why are these plaintiffs suing Ripple in the first place? Because the primary plaintiff had held XRP in 2018 for something like, I don't know, a couple weeks or so, and took a very minor loss, I think in the hundreds of dollars. It was something like that. I admittedly am pulling from memory, but the point is, whatever the specifics are on that, it's very small and over a very short period of time. How could you possibly think that Ripple could have resulted in your alleged investment to increase in value as a result of their efforts if you hold it for 2 weeks? None of that makes any damn sense. And then to go and sue Ripple, well, what the hell are you doing there, you idiot stick? You know, for half a decade. And then if you win as part of the class action, what do you get? Hundreds of dollars, maybe? I mean, it would depend on how the ruling goes. But the point is, it'd be peanuts. And you've been doing this for half a decade? That don't smell right. You know what I'm saying? So there's an XRP community member who goes by the name the Crypto Meme Guy. And he wrote the following. It's not about how much money Vladdy Zakanov lost trading XRP. It's about how much he's being paid to sue Ripple. Please don't spend several years pursuing justice for $250. This stinks of SEC/JP Morgan. And so that's obviously speculation, and fair enough. I don't know what the motivating factor is for this. I'm not going to speculate that he's being paid, although there's no way I'm ruling that out. I have no idea. All I can say is that this doesn't make sense, and I think the vast majority of you out there listening are also kind of nodding your heads going, yeah, what the hell's going on here? Well, I think we can somewhat get to the bottom of this. And it's still speculation, but hang with me here. That was retweeted by XRP community member Mr. Intuitive, and he wrote, I'd like to know who's funding his lawsuit, because no attorney is doing it on a contingence fee to get a percentage of $500. Jeremy Hogan, I know I wouldn't do it for 1/3 of $500. And so the thing is, though, and it's true, nobody would do that for $500. If this goes the way that the plaintiff's attorney is hoping, it would actually be way more money than that. And so here's what attorney Jeremy Hogan said. I think the play here is to let the SEC do all the heavy lifting as to the Section 5 violation, and then, if it is successful, try and sign up 10,000 people to a class action. That's a fee on $5 million. And the XRP plaintiffs each get a gift certificate for a turkey. You gotta love that. Here's your Starbucks gift card. No, it's like, But it is true though. Like you're going to get peanuts, like I was saying a minute ago. If you become part of this class, if certified by the judge, which again the judge has to certify this in order for this to move forward, just meaning validate, you're not going to get a whole lot here. But you know who would get a lot would be the attorney. Because if it's a fee on a larger number, a multi-million-dollar number, now it starts to make sense. So I can't explain. I don't have any great idea as to why the Zakanov individual is hanging with this for half a decade. But at least as far as it goes for the attorneys, that starts to make a little bit more sense, doesn't it? You know, when you're talking about potentially, what if it's 7 figures for this attorney? Okay, well, if it's something that you're just kind of running in the background, you don't have to tend every day, fine, it's been half a decade, but what the hell do you care? And then there was this. So during the the hearing yesterday, I'm going to get to the specifics here in just a second, but during the hearing, John Deaton was feeling frustrated, and he actually tweeted out the following. He said, "I've never been so frustrated in my legal career watching this Zoom hearing." And then somebody goes by the name Big Wayne wrote and said, "Why? Please expand on that." And Attorney Deaton did. He said, "Mainly because I can't speak and address the questions and issues being asked by the judge. The problem is no one understands the tech." Now, folks, that is a major problem. So you're talking about whether or not to certify a class, and the judge is trying to understand the technology, doesn't understand the technology, and is going to make a crucial legal decision without understanding the technology and the implications. That is a major factor. And you'll see as I go through a little bit of the article from the Crypto Basic on this, the judge is talking in the past about how, there's some sort of additional crypto. I can't remember what it was. It was an event or some sort of, I don't think it was a hearing. But the point is that the judge said from the start to the end of the case, those who attended whatever that event was, and again, I'll just have to refresh my memory going through the article again. She stated that we were just as confused in the end as we were in the beginning. So think about that. The judge doesn't understand this still, unfortunately, and I'm not trying to shred the judge or anything, but it seems to be a matter-of-fact statement, and she's going to be ruling on this. It's never ideal. And I'll tell you what, though. I don't know what's going to happen in the SEC v. Ripple case, but it makes me feel much more thankful to have Judge Torres in the SEC v. Ripple suit, because she's been going to great lengths to understand everything about what's going on, including from a tech perspective, which has definitely been presented to her thanks to all of the amicus briefs, I'll tell you that. So then there's this from the Crypto Basic. Here's the headline. California federal judge comments on XRP security status in class certification case. The judge is considering whether to certify the Zakanov versus Ripple class as the case raises a question of first impression. Following yesterday's class certification hearing in the Zakanov v. Ripple lawsuit, U.S. District Judge Phyllis J. Hamilton is considering whether to certify the classes of selected investors who accuse Ripple of engaging in unregistered securities offerings. According to a report from Law 360, a subscription-based law news service, Judge Hamilton noted that the case of whether XRP could be considered a registered security raises a question of first impression. Now, per Judge Hamilton, the Ninth Circuit has not clarified, and this is the most relevant portion in terms of trying to figure out whether or not this thing's going to move forward. Per Judge Hamilton, this is from the judge, the Ninth Circuit has not clarified whether courts can certify classes of investors who are at loggerheads over whether specific cryptocurrencies constitute unregistered securities. So let me just pause right here. A couple of things. First of all, this doesn't mean for sure that this class will not be certified. It doesn't mean for sure it's going to be thrown out, but it causes great question as to whether that may happen, because it is absolutely possible that the judge may throw out the lawsuit. And then I don't know about you folks, but I had never heard the term loggerheads before, so before recording this latest room temperature jam, I did Google it. It's nice to have the sum of all human knowledge at your fingertips and in your pocket via your smartphone at all times. And it just means, loggerheads means in or into a state of quarrelsome disagreement. So basically, when it comes to the status of what the hell cryptocurrencies are from a legal perspective, we're in a bit of an impasse here. And so the judge is articulating that the Ninth Circuit hasn't clarified whether courts can certify classes of investors who are in such a position over whether specific cryptocurrencies constitute unregistered securities. That's it in a nutshell. But the piece continues. The judge acknowledged that certifying such a class is likely a new area of law that has not been addressed in the past. she recounted her experience during a recent judicial conference. Oh, this is what I was talking about, held by California's Northern District. The conference, which had a panel on cryptocurrency securities litigation, left attendees confused at the end. Quote, all of us looked just as confused at the end of the panel as when it began, end quote. That's what the judge said. So, given that this is an area of law that has not been addressed previously, is the judge just going to cram through this class action lawsuit, especially when you know that John Deaton is bringing over 75,000 XRP holders arguing against the handful of people on the Zakanov side saying, yeah, XRP security, the few versus the 75,000 plus? I mean, if I'm the judge, I'm just kind of... Well, I mean, the judge effectively is doing that. It's throwing up her hands because she's acknowledging here after the panel on crypto, just not the foggiest in terms of what's going on here. And unfortunately, this is the judge that is determining this class action. So it's not a personal dig against the judge. I acknowledge this. If you're just thrown into the world of crypto and then you have to make an important legal decision, that's troublesome. But it's her job to figure this out and make a proper ruling. It just makes me concerned because it's like, but is she? Peace continues. However, Judge Hamilton believes that whether crypto constitutes security depends on what prompted the investor's decision to purchase the asset in the first place. It bears mentioning that Judge Hamilton commented during yesterday's hearing on a motion to certify a class of all XRP holders who purchased, sold, and held the sixth largest cryptocurrency at a loss. And so here's the plaintiff's positions. The complainants allege that Ripple Labs held an illegal ICO for XRP without registering with the appropriate authorities, the U.S. Securities and Exchange Commission. The complainants also accused Ripple of using deceptive tactics to increase profits from the XRP price surge, adding that the blockchain company created 100 billion tokens out of nothing while holding an unending initial coin offering since 2012. Yeah, so it's positive, of course. It's bogus nonsense, and I'm so tired of saying this after over half a decade, but obviously Ripple existed after XRP was created. It's just a cold hard fact, but here we are, folks. Peace continues. In the motion, the plaintiff requested that the judge certify a nationwide class and a California subclass of XRP holders who purchased the cryptocurrency from 2017 till date and incurred losses in the process. The plaintiff's counsel, Nicholas N. Spear of Sussman Godfrey LLP, who requested that the judge certify the class, claimed that damages can be calculated by subtracting losses from the initially purchased amounts. The counsel argued that it is relevant whether some XRP investors consider cryptocurrency a registered security. He adds that the SEC already considers XRP as a security and that any class member who is against the premise of the suit can leave. So there you go. For someone like me, and I'm not at a loss, but say, XRP goes down, then I could be considered in this. Well, then, I'd have the option of leaving at least. But think about this. You're talking about, like they have the understanding. There are a number of XRP holders who in 2018 were buying at the top of a big old bump. The biggest price hike for XRP in history. And it happens with every cryptocurrency, happens with Bitcoin, happens with ETH, pick your coin. But there will always be people that are buying the top of whatever. And there are people that did. And so if you consider whatever they purchased, and some undoubtedly put in, substantial amounts of money, and then you consider where the price of XRP is today. And so they're talking about subtracting one from the other, and then, the difference, I guess that's what would have to be paid out or something to that effect. Well, you can see how this would get appealing for the attorneys, right? I mean, that would be undoubtedly a multi-million-dollar class. And then they get a certain cut of that. It's just, good for them. I don't believe that they're being intellectual. So there are always going to be attorneys out there where it's clearly they're just not operating in good faith. There's like, we could make money here, ambulance chaser types. But then, of course, the good news is, on the flip side, you have attorneys like John Deaton who are operating based on some sort of, moral code and ethics and just doing what they know is right. So you have that too. I mean, you're going to have good and bad actors in every profession in life, of course. So it just makes me wonder, what exactly have we encountered here with these attorneys? Because it doesn't look so good to me. Peace continues. Now here's what the defendants had to say. In contrast to this opinion, the defense counsel Andrew Z. Michelson of King and Spalding LLP argued that the suit is excessively broad and does not distinguish between investors who purchased XRP directly from Ripple and those who acquired the asset from secondary markets. According to Michelson, thousands of XRP investors disagree with the premise of the class, and 3,000 potential class members submitted affidavits in the SEC v. Ripple lawsuit attesting to that position. Quote, opting out is not always a solution. It's not sufficient when numbers are this great, end quote. And that's from that attorney, Michelson. The defendant's counsel noted that it is important to consider whether an investor purchased XRP for cross-border transactions or for put profiting and day trading. So that's where we're at right now. I don't pretend to know what's going to happen right here, but if the judge doesn't come to some sort of understanding of the technology and what the implications would be as a result of that, then I don't know how you could possibly move forward with a class action. So it doesn't mean it won't happen. I'm not predicting one way or another. I'm just noting here, based on what she said, and you can see why I'm saying it, it is clear that it's certainly a possibility the judge may throw this whole damn thing out. Because, which, to be clear, if this class isn't certified, that's the same thing as throwing this out. And yes, it is true, from what I understand anyway, that the plaintiffs could appeal that decision, but still, it doesn't mean something would necessarily come from that either. So I guess we're just going to sit tight and see what the heck happens here. But man, when it comes to figuring out whether the claims that are being made as to the assertion that XRP is a security and what the intent is, if you don't understand what the technology is and the nature of decentralization, you're not going to necessarily come to the right conclusion. If you come to the right conclusion, it could just be on accident. So that's why I've got some concern here. I'm not a financial advisor. You should not buy or sell anything because of anything I say or write. That would be a very, very, very bad idea. Until next time, to the Moon Family Sedan.